Well, I got some, let's just call it news. I don't know if I can call it good news or bad news because it hasn't shaken out yet. But yesterday afternoon, the Ninth Circuit Court of Appeals issued an order that Nordyke is going to have to be re-argued. In the meantime, the decision that we reached, the victory on the Second Amendment, has been withdrawn, and it can't be cited, which means, that's right, which means that the right to keep and bear arms that you had in California from April 20th to yesterday has gone away. The opinion cannot be cited for any purpose, Second Amendment, First Amendment, equal protection, anything, until after it's re-argued. And if the new panel of judges agrees with the old panel, then the right will be reinstated. If they disagree with the old panel, then the original decision will be depublished, and then we'll have to appeal to the U.S. Supreme Court to try and correct the problem.
What's the decision?
Well, originally on April 20th, a three-judge panel, the original panel, issued an opinion that said the Second Amendment, as upheld in the Heller decision the prior summer, applies to the states. Well, California, as you know, does not have a right to keep and bear arms in its state constitution. So that means for the first time in the history of the state of California, the people who live in this state had a right to keep and bear arms protected under the Second Amendment. That was why it was such an important decision. Of course, the other states in the Ninth Circuit, Oregon, Washington, Nevada, Montana, Idaho, Arizona, Hawaii, Alaska,
New Mexico.
New Mexico, I think. Those states already had right to keep and bear arms provisions in their state constitutions, so the citizens of those states did have a protection of the right to have a firearm for self-defense. California, as I noted earlier, has no such right. So on April 20th, 36 million, or however many people live in this state, 36 million people had a right to keep and bear arms recognized by the Ninth Circuit. Yesterday, the Ninth Circuit took that right away from you. If I'm successful, the week of September 21st, that's when the case has been set to be re-argued. If I'm successful in convincing a majority of the judges up there to reinstate the right, then it'll be reinstated. Hopefully, I can use this as an opportunity to not only get them to say the Second Amendment should be reinstated, but maybe I can get them to change their mind on the other part of their decision where they said the Second Amendment applies to the states, but a ban on guns at gun shows doesn't violate the Second Amendment. So I'm viewing this personally as an opportunity to try and maybe snatch defeat, or snatch victory from the jaws of defeat. Yeah. So it's pretty rough news for most of you. It was rough news for me yesterday. But my office is already working diligently to get the briefs copied and lined up. The court knows that this is an important case, and they're not wasting any time. They've expedited the briefing schedule. They've expedited the hearing schedule. Instead of having to wait 6 weeks to, or 6 months to 9 months to actually argue the case, they're actually less than 60 days I'll be arguing the case up in San Francisco. So nobody thought this was going to happen. When the court called for an en banc vote back in May, all of the legal experts on Second Amendment, constitutional law, even constitutional law professors that I talked to, said they'll never take it en banc. They'll just say that the vote failed, and then I could appeal to the U.S. Supreme Court the other parts of the decision that upheld the Second Amendment but kicked the gun shows out of the fairgrounds. So I don't know what's going to happen. I can guarantee you this. I've been fighting this case for 10 years. I'm not about to lay down now. I've been burning up the phone lines between here and Battleground, Washington. As most of you know, my co-counsel, at least for the appellate work, is Donald Cates. He's been fighting gun cases for 30 years. I'm kind of a newcomer to this. I've been only doing it for 10 years. I've been talking with my good friend Alan Gura. He and I have a couple of cases pending in federal court in Sacramento. Those cases are probably going to have to be put on hold because they depended on the Nordyke case to try and bring actions against the state of California and the counties of Sacramento for their flagrant violation of the Second Amendment with regard to CCW. But of course, those cases depended on being able to use the Second Amendment as a weapon against the state. Yesterday, when the Ninth Circuit decided they wanted to rehear Nordyke and they depublished the original opinion, our legal basis for saying the Second Amendment applies to the states went away. So that's why this decision is somewhat unfortunate at this particular point in time. Now, somebody, we'll let him remain nameless unless he wants to volunteer his identity, send me a list of questions about constitutional law. I'm happy to go through these questions. I'll try to make them as quick as I can so you get the rest of your meeting. Somebody wants to know, what is incorporation as it relates to amendments to the Constitution? When the Constitution was written back in 1787, there was basically, correct me if I'm wrong, here, 6 or 7 articles, might be 8. 7 articles. Each, for Article 1 deals with the legislature, Article 2 deals with the executive branch, Article 3 deals with the judicial branch, Article 4 deals with the states, and then there's provisions dealing with amendments and ratification. Well, when the original Constitution was sent to the states for ratification, most of the states said no. We're not going to ratify the Constitution unless you include a Bill of Rights. So there was a promise made that the first order of business of the first Congress, if the Constitution was ratified, would be the creation of a Bill of Rights as amendments to the Constitution. And on that promise, enough states ratified the original Constitution to actually create the United States of America. Then, true to their word, the very first Congress, sitting as a committee of the whole, took up the issue of establishing a Bill of Rights. James Madison is considered the father of not only the original Constitution, but he was also instrumental in putting together the entire Bill of Rights. Initially, there were 12 amendments. The first 2, one dealing with congressional districting, and the second one, which eventually actually became the 27th Amendment, dealing with congressional pay, were not initially ratified. And so then amendments 3 through 12 moved up in order, and the original Third Amendment became the First Amendment. The original Fourth Amendment became the Second Amendment, and on down. The Bill of Rights were then ratified as well by the states, and they became the first 10 amendments to the Constitution. However, remember that the federal government, contrary to what exists today, was a government of limited powers. So the guarantees, the individual liberties that were guaranteed in the Constitution and the Bill of Rights only protected you from the federal government. Your individual state government, your individual county government, your individual city government, they could pass laws and deal with you the way that they wanted to. It wasn't until the Civil War and the post-Civil War amendments, specifically the 14th Amendment, that this novel idea was presented, that all of the amendments, all of the protections of national citizenship should apply against even state action. That was the purpose, and that was the reason the 14th Amendment was ratified after the Civil War. So, incorporation is this idea of when and how do the protections of the Bill of Rights apply not just against the federal government, but against the state of California, the county of Santa Clara, or the city of San Jose. There's very, very clear evidence, historical evidence, that the 14th Amendment in 1868, that was the point in time in which that was supposed to happen. However, true to form, the government was resistant to change. And so what has happened since 1868 and 2009 is that the rights that we have, the rights that are enumerated in the Bill of Rights, have piecemeal, one by one, been adopted by the U.S. Supreme Court in various cases and applied against the states. That's what incorporation is. It's the process of making the Bill of Rights applicable against state and local government. Hope that answers the question on what is incorporation. Next question is, what is a fundamental right? And is there a judicial/constitutional definition of fundamental? Well, the smart-ass response is, if it's in the Constitution, it is fundamental. Okay, it wouldn't be there if the Founding Fathers and the Founding Mothers kind of standing behind the Founding Fathers saying, yeah, we need this too. If they didn't put it in the Constitution and mean for it to be a fundamental right, it wouldn't be there. So I know of no judicial or constitutional definition of fundamental right except to say, if it's in the Constitution, it's a fundamental right. Of course, that's my personal belief. There are quite a few judges throughout the ages and a majority of the Supreme Court that have disagreed with me. For example, there's a contracts clause in the Constitution. There's a clause in our Constitution that says the government cannot interfere in private contracts. If we have a contract, you can't set it aside because the government says they want to. Well, in the 1930s, during the New Deal and the first surge of socialism in this country, the contracts clause was rendered a dead letter, and it is no longer used in any constitutional law case to prevent governments from interfering in private contracts. Another part of our Constitution that has been rendered a dead letter is the Privileges and Immunities Clause of the 14th Amendment. So there are various parts of our Constitution that set out fundamental rights that have either been ignored or basically judicially repealed. But the original question to me was, is there a judicial or constitutional definition of fundamental? No, there isn't. Next question, was the Second Amendment ever incorporated? Yes, until yesterday. Was the First Amendment ever incorporated? Yes, it was. It was done piecemeal in the 1930s. First, there was the freedom of speech was incorporated. The freedom of the press came a couple of years after that. The freedom to be free from state-sponsored religion came somewhat after that. The freedom of petition, I believe, has also been judicially recognized. I don't remember the case. What about the Fifth Amendment? Yes, portions of the Fifth Amendment have been incorporated. The Fourth Amendment, yes, portions, in fact, all of the Fourth Amendment has been incorporated against state action. That's why in the state of California, there are statutes, criminal procedure statutes, that allow you to challenge illegal searches and seizure, even in state courts. And in California, the standard is the exact same as the federal standard. It didn't used to be that way. It used to be, believe it or not, that the state of California protected your right to be free from unreasonable search and seizure better than the U.S. Constitution. But a lot of district attorneys and judges and prosecutors got together and passed Prop 8 back in the 1980s. And they said, no, let's get rid of these special protections from the state of California, and let's go with the bare minimum protection under the Fourth Amendment, and now we're under just a federal standard. Was there ever a single moment in time in which any of the Bill of Rights were ever incorporated? That's a trick question. Yes, in 1868, when the 14th Amendment was ratified, that was the point in time in which the Congress at that time, the post-Civil War Congress, said, we intend for the entire Bill of Rights to apply against the states. Remember what happened in 1868. The Civil War was over. The horrible moral sin of slavery had been abolished. But the problem is that people weren't abiding by that. Okay, there were still people in bondage in various parts of this country at that particular point in time. And the state governments, and the county governments, and the city governments, and the local police departments were not protecting the rights of newly freed slaves. And the only way that they could have their rights protected was for the federal government to come in and say to the state of, say, Alabama or Louisiana, you will protect these people's rights or we will. And the way that happened was through the 14th Amendment. So yes, there was a particular point in time, but it has taken more than 100 years for the courts to recognize all of those rights. Was there ever a point in time in which the Second Amendment specifically failed to be incorporated? Another trick question. You know, I grew up as a kid studying history and sitting at my papa's and my grandpa's and my uncle's knees and learning about hunting and firearms. I always assumed that the Second Amendment did apply to me. It wasn't until I got to law school and had law professors tell me that, no, you don't have that right until the court says you have that right, that I kind of learned what has to happen. So the Second Amendment will be incorporated at some point in time, either through the Nordike case or through the McDonald and NRA cases out of Chicago or through the Maloney case out of New York. Nobody that I know of who is a gun rights lawyer is laying down on this issue. Okay? It may not be that it comes out of California. Okay. Were there formal decisions made to incorporate specific amendments and exclude others, or did the current condition regarding incorporation come about by judicial inactivism or judicial activism? Yes. Does the recent Ninth Circuit decision, if it's not overturned, cause the Second Amendment to be incorporated across the nation, or must the Supreme Court of the United States rule in order for incorporation to be settled national law? That question was obviously written before the news yesterday. Right now, there is no incorporation anywhere in the country. Yesterday at noon, before we got the order, the Second Amendment applied to every state in the Ninth Circuit. And I gave you the list earlier. And you can check and see if I'm wrong. There's probably a couple more. In order for the Second Amendment to be incorporated against all states, the U.S. Supreme Court has to make that ruling. So for now, it's a circuit-by-circuit issue until the U.S. Supreme Court takes it up. And right now, nobody has it. Except if you live in the District of Columbia. And I wouldn't live there on a bet. All right, is there a ruling? Is a ruling now forced onto the Supreme Court because of the conflicting rulings in the Ninth Circuit and the Second and the Seventh? Well, as of right now, there is no conflict. The Seventh Circuit in Chicago says you don't have a right to have a gun in your home. The Second Circuit in New York City says you don't have a right to have a gun in your home. And yesterday when the Ninth Circuit said, we're going to set aside Nordike and rehear the case, theoretically you don't have a right to have a gun in your home here either, not protected by the Second Amendment. Now, let me give you some of the good news. I am in no way, shape, or form endorsing Jerry Brown for governor. However, Jerry Brown did file an amicus brief in support of the Chicago cases, the McDonald case and the NRA case. He filed a separate amicus brief, coming only from the state of California, saying that, in my legal opinion, Jerry Brown's legal opinion, the Second Amendment is an individual right. It ought to be incorporated against the states, and we want the Supreme Court to take those cases in Chicago and use the opportunity to overturn the Seventh Circuit decision saying there is no right. Okay? That is the most pro-gun position that an Attorney General has ever taken in the state of California in the history of the state. Now, I don't know if you're a single issue voter or not, but if you are, that means Jerry Brown ought to be governor. Okay? If you're not a single issue voter and you want to balance that off against other things that Jerry Brown stands for, and he is kind of kooky on a lot of stuff. Okay? You know, make your decisions. But do know this. What originally happened is that the Attorney General of the state of Texas got 33 other states' Attorney General to sign on into a brief, basically saying the same thing. U.S. Supreme Court, you should take this case out of Chicago, you should overturn it, and you should find that the Second Amendment is an individual right that applies against local and state governments. When Jerry Brown was asked to join that brief, he said, no, I'm going to write my own brief. And he did. So, I'm not saying Jerry Brown is a friend of gun owners, because even in his amicus brief, he talks about reasonable regulation and how they want to ban certain kind of guns and stuff like that. But on the issue of the right, he is right. Okay? So, that's the good news. And by the way, that's going to be the first thing I'm going to say to the Ninth Circuit the week of September 21st when I get up and argue this case, is that 33 state attorney generals, and the state of California makes it 34. Guess what magic number that is? The number of states needed to ratify another amendment to the Constitution. So, Your Honor, the executive branch of the United States government, when George Bush was president, said the Second Amendment's a fundamental individual right. The Congress and the Senate of the United States of America have, in various legislation throughout our history, said the Second Amendment is a fundamental individual right. Don't you think it's time for the judicial branch to get on board? That's the end of my questions, and I'm taking up too much time as it is. I'll take one or two other questions, and then I'll turn the meeting back over to your leaders here. Yes, sir.
What can we do to help and support you?
Everything that can be done is being done. The order we got yesterday is we have to produce 30 copies of every brief and the excerpt of record that's been filed with the court. And my staff is now working overtime to make those copies and get those bound, because we only have 7 days to produce them. But we only have one copy machine, so I don't know that you can help. But I appreciate the offer. Thanks.
There are other copy machines.
Yeah.
Along those lines, do you want us at the hearing?
That's the other part.
Those hearings are open to the public. And if you want to be there, you're going to have to watch the Ninth Circuit website to find out exactly what day. The order was very cryptic. The case will be set for argument the week of September 21st in San Francisco. The only other en banc cases, by the way, I should probably explain what en banc is real quick. En banc means the entire court. But as is usual in the Ninth Circuit, the entire court doesn't mean the entire court. We have 27 active judges in the Ninth Circuit. We have 21 retired judges who also hear cases. Okay, so theoretically that would mean they'd have to find a courtroom big enough to house, do the math for me, 48 judges, not going to happen. The local circuit rules are that the entire court really just means the chief judge and 10 randomly selected judges. The good news on that is that the chief judge is Alex Kaczynski, and he is on record as being in favor of incorporating the Second Amendment, and he believes that the Second Amendment is a fundamental right. So I have 1 vote, and we have to get 5 more. Okay, 6-5 is a win. But the courthouse in San Francisco is open to the public. You'll have to watch the website to find out what day and what time. Please dress appropriately. It is a very somber proceeding, so you can't cheer or clap or raise hell. You just have to sit there and listen. No cameras. C-SPAN did tape the last argument. My understanding is that C-SPAN has applied. My understanding is that C-SPAN has applied to tape the en banc proceedings as well. All right, I'll switch sides.
Could you say something about the rehearing? Does the court do that arbitrarily? Do they have to give a reason for it? And could they do it in a criminal or a civil case which has been decided maybe guilty or something?
Okay, a rehearing. Normally what happens is that when you do an appeal, if either side doesn't like the result, they have one of 2 choices. They can ask for en banc review or appeal to the next higher court, which would be the U.S. Supreme Court. In this particular case, neither side asked for en banc review. We were in the process of preparing a petition to the U.S. Supreme Court for review because we disagreed with the court's sensitive places doctrine and the banning of the gun shows, although we agreed with the incorporation analysis. Well, the time for filing en banc review came and went, and neither side filed a petition. But one judge, or at least one judge on the court, asked for review. That was when we were required to file new briefs, and then a vote was taken, and apparently a majority of the judges do want the case reheard. En banc review is available for every kind of case, criminal or civil. They do not review findings of fact, they only review issues of law. Yes, sir.
So the question, thank you for that explanation. So was the majority vote of the sitting 27 or all 48?
Of the sitting 27, one judge recused herself, so it was a majority of 26 judges. So theoretically, it took a minimum of 14 judges to say we want this case reheard.
And is it your thinking that they wanted it reheard, precisely kick it upstairs to the United States Supreme Court?
In the Ninth Circuit, en banc procedures are secret. We're not allowed to know which judges voted which way. We're not allowed to know what the vote count was. We're not even allowed to know what memorandums or reasons they're giving. I have no idea, going into oral arguments, what the court wants to ask me questions about. It could be the First Amendment issues, it could be the Second Amendment issues, it could be incorporation, it could be sensitive places, it could be equal protection, it could be a matter of procedure. I don't know.
So you have to prepare for all of them.
Yes, I have to prepare for everything. There is some rumblings that en banc voting procedures should be open to the public, and it would be wonderful if CNN or Fox or Time Magazine or something could file a lawsuit and find out what the hell happened, but I don't have the time or the money. I'm going to take 2 more questions and that's it. Is that okay with you? One.
One more question.
One more question.
Sotomayor, she's on the Supreme Court when the Second Amendment issue is reviewed by the Supreme Court. Do you think that that's a possible strategy that's working in the background here?
I don't know. See, she was one of the judges in the Maloney case out of the Second Circuit. So arguably she has to recuse herself from sitting on that case. But she doesn't have to recuse herself on the Chicago case, and she wouldn't have to recuse herself on the Nordike case if it came before her. So, and I wouldn't necessarily be too quick to assume that she's anti-gun. She probably is, okay? But I don't know for certain, okay? I've seen stranger things happen. Even Judge Reinhardt in the Ninth Circuit several weeks ago, wrote an order dismissing a case against gun manufacturers. So liberals do learn. In fact, the quote I'm proudest of yesterday, and I'll close with this, when the newspaper guy asked me, "Why do you think that the liberal Ninth Circuit wants to review your case?" And I said, "Well, maybe they want to view the second. Maybe they want to apply the Second Amendment liberally." We'll see. All right. Bye. Thank you, Tom.
Our featured guest speaker is going to cover just about everything else.
True, but that legal lesson was worth its weight in gold. If you had to pay tuition, none of us could afford it. I had the honor and the pleasure of sitting in the front row with some of our friends here at the Nordyke hearing in San Francisco. And I'll tell you what, I have never been more proud of listening to somebody argue the Second Amendment than when Don Kilmer was representing all of our rights, the rights of every citizen of the United States. And we're we have the A-team here, and it's just awesome. Feel secure that the direction that he's going in is the right direction. Unfortunately, none of us can figure out what the courts are going to do. If we could, we might live in a free country again. But
Yeah.
a couple of things I want to do. First of all, for the new people, I'm Sam Paredes. I'm Executive Director of Gun Owners of California. We're the oldest pro-gun political action committee in the country. Started in 1975 by my boss, Senator H.L. Richardson, who was sitting on the board of directors of the National Rifle Association back then. You folks will remember Harlan Carter and Neil Knox and the whole gang that was running the show back then. Well, when H.L. said, we have these funny gun laws in California, and it was just after the Nixon debacle, and they created these political action committee things, these PACs. Nobody knew how to do them. Well, he figured out how to do them, so he went to Harlan and said, "Hey, we need to set a PAC in California to fight off some of these handgun bans they're sponsoring." And Harlan said, "Go right ahead." So he did, and we've been here for 34 years. We do only a couple of things. We lobby in the legislature, and I'll tell you about some of the lobbying activities that we've been doing and how we choose to lobby. And we participate in the elections. All of us are life NRA members. We're all shooters. We're all dyed-in-the-wool hunters. But we're also political activists and political scientists. And we choose to dedicate our lives to defending the right to keep and bear arms, using the skills and the experience that we've gained doing this. I've been doing this since 1980, so just a little bit of time. So that's what Gun Owners is about for the new folks. Everybody else, first of all, I want to thank you for your support. You guys have been awesome. I get to see membership blanks and contributions and all those things when they come by the office. Thank you so much. I know that a lot of you folks are there, and it is greatly appreciated. And that's the only way that we can do what we do. Okay? First of all, let's talk about legislation. 3 main bills are left in California. First of all, as I mentioned last time I was here earlier in the year, we killed everything. Don, see ya. Thank you. We killed all the bills. And as I mentioned, we killed them not because I have a pretty face and a golden tongue, and I was able to convince all of these liberals that the Second Amendment was our God-given right, and that these bills they were sponsoring were stupid. They didn't believe me. They tried to pass them all. We were able to kill them because we understood the system. We were able to make sure that all of the bills had a cost to them. We forced them to be honest. And when push came to shove, and they're talking about funding welfare programs for the really needy, the orphan kids, the blind, the disabled, versus sponsoring and paying for gun control programs that have proven not to work in the past, they made the right decision. They killed all those bills and used the funds for everything else. We can argue about the welfare and all that stuff some other day. But they made a decision based on their own liberalism. They weighed the issues and decided, you know, we need to spend the money here, the little that we had. Well, this year, we're in a similar situation. You all know they just passed the budget. It was actually it was about $26 billion upside down. And thanks to the leadership of some of our friends, like Senator Dennis Hollingsworth, the Senate Republican leader, Assembly leader, Republican leader Sam Blakesley from San Luis Obispo. They held the governor's feet to the fire. They gave him some backbone. They put air in his elevator shoes, and he stayed strong. He stayed strong. The reason he stayed strong is because a little bird spoke into his ear and said, "Governor, you are about to go down in history as the worst governor that's ever served the state of California, bar none." He didn't like that. He didn't like that. He said, "Your legacy is horrible. You're all over the map. You've raised taxes. You've gone back on your promises. You're a laughingstock." I said, "Well, what can I do to fix this?" You know? He said, "You know what? You've got a year and a half. You've got to be tough. You've just got to hold the line. You got to keep your word. You can't raise taxes. You got to stand up to the liberals and fight them tooth and nail." And he did that to a great extent. We can talk about the budget. It's ugly. It's massively ugly. But you know what? There's some things that we've wanted as conservatives, as taxpayers, for the legislature to do for a long time. And they got some major reforms that are going to save the state of California probably $40 or $50 billion in the next 5 years. There's a lot of welfare reform. I won't go into detail. Tons of welfare reform. They finally put law-abiding citizens and illegal aliens on the same level, as opposed to giving illegal aliens unlimited help and limiting the help to legal residents of the state of California to 5 years. Now at least the illegal folks are on the same footing as we are. That is a saving of billions of dollars. So there's some good things that happen. We'll hear all of the whining and crying and all of that stuff. And Senator Hollingsworth told me, "Sam, you know what? This is just the first step. Big step. Because we're going to be back here in a few months. The state is already $6 billion in the hole as of yesterday. So they're going to be at it again." Remember, they passed an $86 billion budget. Remember what our budget was last year and the year before? Over $100 billion. So they made some significant changes, and it's just the beginning. They better hang on. The Democrats said, the liberal leadership of the legislature said, and I can't limit that just to say that it's all the Democrats, because there were a lot of Democrats who were saying, "You know what? You pass taxes and I lose my job in my district. I'm not voting for this crap. So you guys better figure out where you're going to cut." And that's exactly what they did. But you know what? We created that situation for them. We put them in that Hobson's choice that they had to make. Fish or cut bait. You're going to cut off your left finger or your right finger. If you're right-handed, you better cut off your left finger. So that's the kind of choice they had to make, and they did that. So there's some interesting times to come. We're not there yet. We made some major strides. No matter what you hear in the press, most of the newspapers got it wrong. And they won't get it right for probably 6 months to figure out exactly all of the changes and the reforms that happened in the budget. But needless to say, I spent a couple of nights sleeping on the floor of my friend Senator Hollingsworth's office while this fight was going on, because all along, gun issues are always in play. So we're there to fight to make sure that they don't do something goofy, and to be there to try to take opportunities to get some of the gains that we need to get. Let me tell you what we've done. Let's start with SB 585, gun show ban at the Cow Palace. Senator Leno, he He's pushed this thing. It's made it all the way through the process. It's now on the floor of the assembly. Well, yesterday, my colleagues and I, Kathy Lynch from the National Shooting Sports Foundation and Safari Club International, had a meeting with the Department of Finance. And we pointed out to them that the state of California is actually losing over $170,000 a year, at least, only in the revenues that come to the Cow Palace to operate the place. State-owned facility. If they don't make this money, guess who gets to pay for it? We all do through our taxes. They backfill that. So the Cow Palace Gun Show is making money, and it's saving us from having to put out more of our taxes to pay for that thing. Also, they didn't take into account, they kind of overlooked the fact that about 600, depending on the show, between $600,000 and $700,000 worth of business is conducted in the gun show. And all of the sales tax revenue that's generated from that event would vaporize if they ban the gun shows at the Cow Palace. Puts another pressure on the general fund. So we're working to try to get the Cow Palace bill put back, sent back, re-referred to the Appropriations Committee in the Assembly. If we do that, that means it'll go into the suspense file, and the same thing that happened last time will happen this time, is that they're going to have to pick, they're going to have to say, okay, at the end of the year, how much money do we have to spend? And they're going to go in their pockets, and they're going to go like this, and realize that they're not going to go like this. For those who didn't, that was a 380 magazine. They're going to find that they don't have any money and they can't afford to lose the money that they're going to lose if they pass the bill. So that's what we're working on. We're also, we just also introduced a whole bunch of amendments to be added to this bill if it does stay on the floor. Amendments like, well, if you can't have gun show there because it doesn't reflect the morals of the community, why do we have the erotic, exotic ball there? Why can we have rave concerts where they've actually had murders, arrests for drug violations, unruly conduct, assaults, battery, all kinds of things have happened at these events? Why? Is that under the protection of the First Amendment, that the Second Amendment isn't protected? As a matter of fact, it's our First Amendment right to be able to express ourselves by viewing, buying, caressing, drooling over guns and ammo. That's our right. So we've got an amendment to do that. A couple of other technical amendments that we're going to do, try to jack this thing around. We want to create enough of an aura so that if it does go to the governor's office, he will understand if I sign this bill, it's going to cost the state of California money. It's going to take a state facility that we all own, not the people, the residents of San Mateo County or South San Francisco or San Francisco. We all own it. And we should be able to do anything that we want to do that's legal in the state of California in that facility. And he'll veto the bill if it gets that far. That's where we are on the Cow Palace bill. Second bill, SB 41. Senator Alan Lowenthal, California's own bonehead from New York.
Schumer. Chucky.
Schumer. Our own Chucky Schumer.
Schmucky Schumer.
Senator Alan Lowenthal is carrying a bill for a staffer in, believe this or not, he's carrying a bill for a staff member of the Democrat caucus named Erwin Noy. He needed a bill to keep him busy. So he's carrying this bill. And what this bill says is that when you buy a gun, you're going to have to put another signature down on a state form to say that I actually picked up this gun when I bought the gun. Now, in committee we testified, well, folks, you sign the 4473, which is a federal form, when you pick up a gun. You sign an affidavit, a handgun, we're talking about handguns here. You sign an affidavit that says that the dealer has shown you, which he is required by law, how to properly and safely operate the gun, load it and unload it, the major features of the gun. You sign that affidavit by law. every dealer gives you a receipt that they have you sign for their own purposes that says the price of the gun, the tax on the gun, the date you picked it up. All of that information is already there. If you have a gun safe, you sign another affidavit that says, I don't have to buy a stinking trigger lock to take this handgun out of the store because I have a California-approved gun safe at home. I swear under penalty of perjury that I do. So you've given all of these signatures. They're all required by law. But the state of California, or Senator Lowenthal or Erwin Noack, believes that you need to sign the DROS form, the dealer record of sales, to prove that you actually not only purchased the gun, but you picked it up also. And the reason that he wants to do that is because his girlfriend is a deputy district attorney for San Francisco, and he came up with some story that she was charging some felon for illegally purchasing a firearm. He's a prohibited person. And he's testified, yeah, I bought the gun, but when I realized that I was ineligible to have it, I didn't pick the gun up. Well, because she chose not to call the dealer and say, did this guy pick this up? Is there evidence that he picked it up? And the dealer would have said, yeah, I've got 4 signatures that say this guy picked up the gun. And it means that the Department of Justice failed in letting us know that this guy was a prohibited person. Okay? Didn't want to do that. She felt that she should just be able to call the Department of Justice. And the Department of Justice should have some sort of record and a database as to every time we pick up a gun, were we the actual people who picked up the gun? That's $20,000 down the rat hole. That's what it costs to sponsor every single bill in the state legislature, whether it passes or not. If it passes, then you add whatever appropriation is on top of it. But $20,000 down the rat hole for this bill. There's some folks that say, you know what, that's not that big a deal. You know? Every inch, every sliver, every razor blade thin portion of our rights that we give up is unacceptable. If we say this is okay, not that big a deal, what's next? We can't come back and say, you know what, this isn't working out, we want to get rid of it. They say, hey, you guys support, you didn't care. You didn't care. So we're there fighting it tooth and nail. And that bill is in the Assembly Appropriations Committee in the suspense file because there's actually a cost to it. It costs $60,000 the first year and then $1.6 million for the next 2 years just to develop the database to maintain the information. Okay? Well, can you guess how much money the state has to spend on this? Like double pot. You know? So we're pretty confident that we're going to kill this bill. And then again, we've got some people whispering in the governor's ear, you know, this is more cost to the state of California. We don't have the money. Remember, you're going to be the laughing stock in the history of California. You probably ought to think about vetoing this bill. Don't even issue a message. Just veto it and let it go. So that's where that is. The last one, AB 962, the ammunition registration bill. This is the big, I don't want to say granddaddy because I love the only grandfather I knew very much. And I don't want to taint him by using a word that I used for him, papacito. He was Mexican, lived in Tijuana, loved America, came here during the war and learned to speak English and told my family, if you guys don't move to the border and the kids come to America, you're never going to see me again because I love this country. So that's how my family came to the United States. And then my mom and dad are citizens and all that. So anyway, I'm proud of that. So. This is the big bad wazoo. Ammunition registration, actually it's registration of ammunition purchasers. Every time you buy handgun ammunition, you would be treated like a child molester, a sexual predator, a felon. You will have to put a thumbprint down and give all of the information. As a matter of fact, some of you might remember, back in the day, from 1968 to 1986, when all of us had to fill out this book. At every dealer, every grocery store, every mom and pop, every liquor store that sold ammunition, we had to put in our name, the date, our name, our address, the manufacturer of the ammunition we were buying, the caliber, the quantity, our birth date, our driver's license or social security number. And the information had to be verified by the person that was writing, keeping this book under federal law. How many criminals, how many crimes were solved by this program from 1968 to 1986? You're doubly right, you're singly right. And it doesn't include a number, because zero, I understand, is not actually a number. Not a single crime was ever solved from a gun registration program that was required by law nationwide. Okay? Now, Assemblyman De Leon, who is actually the assemblyman from the district where I grew up in East LA, he said, you know, that's ridiculous. There were a lot of, how did he put it? There were a lot of right-to-work states who ignored the law and did not comply. Let me translate that to you. There were a lot of redneck, red meat eating, Bible-loving, flag-waving states in the nation who did not comply with this law. You know, and they probably still had slaves. You know? And that's why it was ineffective. You know what? He has no evidence of that, number one. Number two, if it did, there were millions upon millions of records that were kept. They were available to police officers, federal and state and local police officers at the dealers for them to inspect to see, okay, let me check here. Scott Anthony, Samuel A. Alexander, no, he's not a felon. Cheryl Ann Toey, no, she's not a felon. Alonzo Oliver, uh-oh, he's a gang member. I'm going to go look it up. He bought some Norma 32 Smith & Wesson, one box. We're going to have to check him out.
You could kill 50 cops.
Yeah. With one box of 25 AC. Well, let me tell you, folks. It doesn't work. So I brought that up to Assemblyman De Leon in testimony, and we've got kind of a hate-hate relationship.
You see eye to eye.
Yeah, we always. Yeah. I had a barrel in my case. Guess who's holding the barrel? So he says, you know what? That was back in the old days, in the ancient days before the internet. Before the internet, before the modern age of communications. You know, police officers would request information, they would get it by snail mail, he said. Snail mail. Boy, he's giving a bad name to snail. You know? But the fact of the matter is, he amended his bill to do exactly what the 1968 Gun Control Act did. This information does not have to be transmitted to the state of California over the internet, you know, on computers. It does not have to be sent to the FBI or anybody else. It has to be kept in the dealers, exactly the way it was in 1968. So he's amended the bill to be, again, completely ineffective. Now, we have two jurisdictions, the city of Los Angeles and the city of Sacramento, who have their own ordinance. As Don was talking about earlier, that since we don't have incorporation, local governments can do their own thing, and that's what they've done. So they actually make you do this in Sacramento City and in the city of Los Angeles. And they come up and say, you know what? We captured 20 felons with guns because of this program. We sent police officers down, and they went through these and saw, Orale, Jose Vargas, who's a member of the 18th Street Gang, we know that. He's not supposed to have a box of Remington 38 Special. He's not supposed to. It's illegal for him to possess it. Now, let me tell you, I'm a Mexican, so I can make Mexican jokes, so don't get mad at me. And if you make a Mexican joke, I'll laugh with you. But the exact same thing is in place. Now, they say they arrested, these 10 guys or 20 guys, and they captured 100 illegal firearms based on the investigation because of this program. Well, let me tell you, one thing that they did not like to hear when we were testifying. They cannot even actually charge somebody with a violation of this program if they're a felon. It's a violation of their Fifth Amendment rights to require them to comply with a registration program where they would be admitting that they're a felon. So even if they lie, they can't be arrested. They can't be charged with that. Okay? So here they have a law that only applies to us. It only applies to us. And of course, none of us are going to break it because we're all law-abiding citizens. So it's nothing more than an inconvenience on our lives. Okay? Now, the reason that these two jurisdictions said we want this program is because we have it here, but the criminals, they just go to Sacramento County and they buy their ammunition. They go to Walmart and they get their handgun ammunition on Greenback Lane instead of in the city. In Los Angeles, they say, oh, they just go, they go across into Orange County and they buy their ammunition, and they drive from Watts to Orange County and buy their ammo, and they come in and do their drive-bys in Watts. Okay? Well, we pointed out, you know what? If that's the case, these guys, there are stories that you guys have brought to the legislature as law enforcement agents about these guys coming in and taking hundreds of pounds of illegal drugs worth millions of dollars and throwing them in the trunk and driving from one part of the state to the next or to another state to ply their trade, their criminal trade. What makes you think that these guys aren't going to drive to Reno, Nevada, go to Cabela's and buy all their ammunition because whether it's legal for them to buy it or not, but they don't have this law, and then they're going to come down here and give it out to all their boys. That way they completely avoid this program. Criminals are not idiots. They're not dumb. They're stupid. Okay? They've chosen the wrong way. Many of these guys are incredibly smart. I mean, if you can make gunpowder in a federal high maximum security penitentiary, you can figure out how to do that. You can figure out how to get ammunition. Again, these bills only affect law-abiding citizens. Okay? This is also going to cost millions and millions of dollars, and it's going to be to impose this. It's going to cost lots of money. So we've got it sent to the Appropriations Committee suspense file. Now let me tell you, and I'm going to have fun, and I'm going to poke fun at some of my colleagues. One of the program lobbyists thought it was important to point out to the committee that, you know what, this program will take away funds from the dealer record of sales fund, the fund that we pay when we buy a gun, goes in there to pay for our background checks. Well, they also use it for law enforcement things, and they said if this bill will put more pressure on that so that the Department of Justice can send inspectors to inspect machine gun dealers and prop houses and things like that. That wasn't an argument that I thought was going to carry any weight with the committee. And then another colleague got up and said, yeah, what he said, and it's going to cost more money and they're going to have to raise the fees. And then we thought that it was important to point out that in the state of California on any given year, we have $546 million on the average in retail handgun ammunition sales. Handgun ammunition, $546 million. Now, the author, Assemblyman De Leon, he always says, hey, one of the provisions of my bill is we're going to take all the ammo, handgun ammo, and we're going to put it behind the counter. You know, like we do with drugs and spray paint and tobacco, so that you can't get it. And we've said, you know what, that's stupid. First of all, you're going to suppress the sale of ammunition, which is probably what you want to do. But that's just not a feasible thing. We have a lot of gun stores in the state of California that have 1 or 2 employees. They're going to have to stand at the handgun ammo counter and go, here, you want to look at this box? The guy opens it up and says, no, I don't like what that looks like. Put that back. How about that one? Oh, like this one? Okay, no, I don't like that one. And they're never going to be able to conduct any sort of business. It's not practical. But being the smart political scientists and wise, smart Alex we are, we listened to what the knucklehead said, and we went to the spray paint industry and the pharmaceutical companies and said, what happened when you were forced to put these products behind the counter? And they both said the same thing. We saw a 30% drop in our sales of those products in the places where they forced us to do that. 30% drop. So we went, oh, that's great. Thank you. Okay, $546 million in retail sales. Let's be conservative. Let's just take 25%. That's $154 million times the ongoing sales tax at the minimum level. That's $12 million that the state of California is saying, we don't want that sales tax generated from handgun ammunition. When I mentioned that, the chairwoman of the Senate Appropriations Committee, Senator Kehoe from San Diego, her eyes kind of went, what? I said, yeah. And this information is available. You want the phone number for the lobbyists from the paint industry and the pharmaceutical? They're probably sitting out there right now. Why don't you ask them? And she said, you know what? That's important information that the committee would really like. And that's exactly the information that they're going to be able to use. Some of the members in the committee will line up with the Republicans and say, you know, we can't afford this.
Way to go.
It has nothing to do with the fact that this is a violation of our Second Amendment rights. It has nothing to do with the fact that this is a stupid bill. It has everything to do that we know how to work that system and what information is important to give to them, to understanding how they're making decisions. Now, if we were in a year back when we were in the dot-com boom and everybody in San Jose was working for a dot-com company making millions of dollars, and the state was generating all kinds of income tax and sales tax, we probably would lose every one of these cases. But understanding the situation that we're in right now, the environment that exists, understanding the players is the way that we can serve you best by killing these bills. And it just takes, you know, people say, hey, I want to come up and work with you and be your, learn how to do this and volunteer to do this. And I say, you're welcome to come. But I'll tell you what, it's taken me 29 years to figure this thing, 29, let's see, 80, 90, 2000, yeah, 29 years to figure this thing out. And the other folks that I lobby with, they've been doing it for a long time. And we're dedicated, our lives are dedicated to doing this. And I'm not saying that there aren't other good people out there and somebody else is going to figure out how to do it better. We don't have the most money of any group out there. We're actually the smallest pro-gun political action committee in the state of California. But we've kind of figured out how to do this thing. Now, I know some of you guys folks are thinking, how did they make gunpowder in the maximum security? I'll tell you what this rocket scientist did. Took a pie plate, urinated into it every day for who knows how long, let it evaporate. Residue? Nitrates. Smoke cigarettes. Every time he lit a match, scraped off the carbon, off the burnt match. Carbon. Nitrates, carbon. Now, he didn't have saltpeter, the other major component of sulfur, but he did. He took the Strike Anywhere matches and cut off the white tips on those matches, put them in there, mixed it together. Took a pencil. Every day, you know, the magazine rack came by, he'd take a magazine, and he wouldn't tear out any pages because they actually inspect them. He took out